Hello and welcome to Lex Nova Abogados Jr. Today, we're diving into a very important legal topic, the guardianship of children and adolescents, also known as tutela. So, what exactly is guardianship? In broad terms, tutela refers to any kind of protection, care, defense, and guidance for people and their interests. However, it's mainly understood as a legal institution designed to protect minors and their property when they are most vulnerable. Normally, children find protection within their family. But what happens when that family structure isn't there? That's when the law steps in with a different system of protection, placing the child under guardianship. In essence, guardianship steps into the role that the family would typically play. Legal scholars define it as a protection system established by law for minors who lack a parent exercising parental authority. We can summarize it like this. Guardianship is a legal power granted to a capable adult to protect, represent, and manage the assets of a minor, effectively filling the void left by the absence of parental authority, although with slightly more limited powers. It's a crucial safety net for children in need. Now, let's explore the fundamental principles that govern guardianship. First, guardianship is a representative function. The guardian acts in the name and on behalf of the child. Just like with parental authority, the guardian steps in to handle legal matters because the minor cannot. However, this representation is always in the child's best interest. This means the guardian doesn't have unlimited power over the child's assets. For major decisions, like selling property, they need court authorization. Also, there are certain personal acts where no one, not even a guardian, can represent the child. Second, guardianship is considered a social duty. It's seen as a public service. This means that if you're appointed as a guardian, you can't just refuse. To be excused from this duty, you must present a valid reason to a judge who will then decide what's best for the child. Our civil code states that guardianship is a duty no one can excuse themselves from, except in specific cases defined by law. Finally, guardianship operates on a principle of unity. This means there is only one guardian. This is different from the principle of personal function we just discussed. Having a single guardian avoids potential conflicts and disagreements that could harm the child's interests. Multiple guardians could lead to clashes over decisions and create confusion in representing the child. So, when does the process of establishing guardianship begin? It starts when a non-emancipated minor lacks the protection of parental authority. This could happen due to the death of both parents, their absence, or if they've been legally stripped of their parental rights. The state's involvement happens through the courts. In our system, the competent court is the Court for the Protection of Children and Adolescents. The entire process, from opening the case to appointing the guardian and overseeing their duties, is managed by a judge. According to legal expert Aguilar Gorondona, the process has several phases. First, there's an initial phase where the need for guardianship is established and ordered by the court. Then, permanent guardians are appointed. After that, the appointed individuals formally accept their roles. And finally, the guardian must complete all the legal formalities required before they can start exercising their duties. The process is initiated when the court is informed of a situation requiring guardianship. Certain people have a legal duty to provide this information. This includes public officials, like the one who registers a death certificate for a person who left minor children without a legal representative, family members, especially close relatives, and any guardian named by the parents also have this duty. Failing to report this can result in fines. Once the need is established, the next step is appointing the guardian. There are different ways this can happen. This is called delation in legal terms. The first is paternal delation, where the parents themselves designate a guardian. This is also known as testamentary delation because it's often done in a will. Next is legitimate delation, where the law directly designates who should be the guardian. And finally, there's dative delation, where a judge makes the appointment. The parent's choice of a guardian always takes precedence. The law assumes that parents, out of natural love, know who is best to care for their children. So, their designation overrides any other, unless the parent's past behavior suggests otherwise. The power to name a guardian is a personal right derived from parental authority. For a parent's designation to be valid, certain conditions must be met. The appointment must be made in a public document or a will. The parent making the appointment must have been exercising parental authority at the time, and at the moment the guardianship is needed. That parent should still have been exercising parental authority or have lost it only due to insanity or absence. What if the parents didn't name anyone? This is where legitimate delation comes in. The law says that guardianship then falls to the surviving grandparent or grandparents. If there are multiple grandparents, the judge will decide which one is best suited, always considering the child's best interests and well-being.